This video will explain who can get a temporary protective order and how it is different from a temporary restraining order. A temporary protective order can be granted to a victim of one of 5 crimes: sexual contact, sexual penetration, lewdness, stalking, or cyber-harassment, who does not have a domestic relationship to the offender. A temporary restraining order can be granted to a victim of domestic violence, meaning one of 19 specific crimes where a domestic relationship exists. Watch our TRO-FRO series to learn more about temporary and final restraining orders. Who can apply for a temporary protective order? The victim can be of any age. If the victim is under 18 or has a developmental disability or mental disease or defect, a parent or guardian must be the one to file for the temporary protective order on their behalf. What are the eligible sexual offenses? The law says that the person applying must be a victim of non-consensual sexual contact, penetration, or lewdness, or an attempt at any of these crimes. This means that the offender touched or caused the victim to touch their intimate parts without their permission, directly or through clothing. This includes acts of penetration of intimate parts as well. It could also be the offender showing their own intimate parts without the victim's consent for their own pleasure or someone else's. These acts do not actually have to be completed. An attempt to do any of these things can also qualify for the protective order. What is stalking? Stalking is watching or following someone more than once in such a way that it causes them to fear for their safety or experience emotional distress. It is legally defined as engaging in a course of conduct, meaning 2 or more times directed at one specific person. This could include following someone's movements or whereabouts themselves, through a third party, or with an electronic device. It could also include repeatedly harassing them or repeatedly communicating written or verbal threats to a specific person. What is cyber-harassment? Cyber-harassment includes sending an electronic communication, like a text, Snap, or Instagram message, to another person that threatens to cause physical harm or commit any crime against a person or property. It also includes knowingly communicating in an online capacity lewd, indecent, or obscene material with the intent to emotionally harm someone. Who can be an offender under a temporary protective order? In order for a temporary protective order to apply, the offender has to be over the age of 18. If the offender is under 18, the matter can be reported to the police and it will be dealt with in the juvenile court. If the victim is a minor and the offender is a parent or guardian, the victim would not be able to get a temporary protective order. Instead, that case would be reported to the Division of Child Protection and Permanency, or DCPP, formerly known as DIFAS. The offender cannot be someone that the victim is or has been married to, ever dated, shares a child with, or with whom the victim ever lived. If one of those relationships exists, the victim can seek the protection of a domestic violence temporary restraining order. There is no requirement to report these offenses to the police. The victim can still get a temporary protective order even if there are no criminal charges. The police cannot issue a temporary protective order, only the superior, meaning the family court, can. A victim can go to or call their county courthouse from 8:30 a.m. until 4 p.m. A victim may also go to the county where the defendant lives, the act occurred, or where they sought safety. What can a victim ask for? When a victim gets a temporary protective order, the goal is for the court to enter a final protective order. A final protective order is a court order entered in family court that makes it a crime for the offender to contact the victim or go to their home or place of employment. If the court enters a final protective order, the order will last for the victim's lifetime as long as there is no further order changing those restrictions. The order can also prohibit an offender from having contact with the victim's family, employers, employees, co-workers, and even an employee or volunteer of the Sexual Assault Response Agency. A protective order, whether temporary or final, orders that no future offenses should be committed against the victim. The offender cannot stalk, threaten, or harass the victim. The offender would not be allowed to go to the victim's home, school, or work. This applies to the victim and their family and household members. If the victim's safety would be increased if the offender stayed away from other specific places, like a place of worship or the gym, the victim can request the court to order that the offender not be allowed in these places as well. Any other specific relief to the victim's situation that would increase the victim's safety can also be requested. Again, we are talking about a family part court order. This is not a criminal charge for the offender. It is not something that appears on a criminal background check. It can, though, be enforced by the police. Violating this order is a crime. If the offender contacts the victim after a protective order has been entered, the police should be notified and the offender could be arrested for violating the order. Legal Services encourages victims to seek legal advice regarding their specific situation if possible. To speak with an attorney at Legal Services of New Jersey, you can complete an online intake at lsnjlawhotline.org or by calling 1-888-LSNJ-LAW. To get the fullest sense of a victim's rights in this area, view all 3 videos in this series. Victims of sexual offenses can also reach out to their local sexual assault agency. The list of agencies can be found at the website for the New Jersey Coalition Against Sexual Assault, or njcasa.org. Victims can also reach out to the New Jersey Coalition to End Domestic Violence at njcedv.org.